Good morning. Today is June 4th, 2024, and I am Chair Michelle Espinosa, and I'm going to call a Real Estate Commission meeting to order. May I have roll call?
Michelle Espinosa,
Here.
Renee Lind,
Here.
Autumn Rubal,
Here.
Erica Doyle,
Here.
Graham Kaltenbach is absent. You have a quorum.
Great, thank you. And really quick, I would like to welcome our new members of the commission. Thank you for joining us. Hopefully this meeting will be a nice break-in for you. We have the approval of the April 2nd, 2024 Real Estate Commission meeting minutes. But Angela, would you just give us a quick overview on this voting?
Sure, the procedure. As Marcia said, you do have a quorum because you have 4 members present today. What's required for action to pass on an item is for there to be a majority vote. So my recommendation to the 2 new members, Autumn and Erica, is that you abstain as your vote on approving the minutes because you were not present as a commissioner for those meetings. And then Michelle and Renee, assuming that you vote to approve the minutes, that will be your majority vote, 2 in favor, none opposed, and those minutes will be approved. Does that make sense?
Yep.
Yes. Great. So may I get approval of the April 2nd, 2024 Real Estate Commission meeting minutes?
I move to approve the minutes.
All right. And I can second, correct, Angela? I will second. All those.
Or a new member can as well.
Okay. I'll go ahead and second. Any discussion? All those in favor?
Aye.
Aye. And we have 2 abstaining.
Abstain.
Abstain.
All right, that's 2 in favor. Motion passes.
Thank you.
All right, do we have any public presentation of issues not on today's meeting agenda? Eric, you're muted.
Sorry. And Madam Chair, I just wanted to remind everybody in attendance that the commission did update their rules, specifically 4.5H. Prior to 2020, you had to be in person to obtain continuing education credit for attending a commission meeting. That was updated since all meetings are virtual now. So if anybody's interested in getting CE, as long as the commission meeting lasts for 2 hours, we have launched a poll. If you want to put your name and email address on there, we will send out a CE certificate if the commission meeting lasts for a minimum of 2 hours. Please put your license name and be able, so we can be able to identify you with your registration. We will send a CE certificate out afterwards. And if we could just give a minute for anybody that wishes to obtain that to fill that out. Just give it 30 more seconds. People are still completing it. All right, and we will close that off. And if anybody from the public would like to address the commission, there is a hand icon. If you want to hit that icon, we will call your name and unmute you. Madam Chair, I do not see anybody wishing to address the commission.
Okay. All right, we are going to move on to policy matters. Marcia?
Given that we have new commissioners, would you like to do an introduction of them and just have them kind of give you their background? And I'll make it a little easy on them. Autumn is a public member. Erica is a licensed member. So Erica, would you like to lead off and just tell us about yourself?
Okay, well, thank you very much. I have just been in real estate for over 20 years. I am on the Western Slope. I live in the Grand Junction area. Looking forward to being able to help as I can on this. I've always appreciated what the commission and the staff do. And diving right in, I will turn this over to the next person.
Autumn, it's your turn.
Hi, everybody. Good morning. I'm Autumn Rubal. I'm a Colorado native. I live in Denver. I'm also equally excited to be on the commission as a public member and to help wherever I can. And I look forward to getting this first one under my belt.
With that, commissioners, you don't have any policy matters on your agenda today. Is there anything that you would like to have on your agenda for the August meeting?
I'm good.
I'm good.
I'm good.
Okay.
All right, we are going to move over to complaint investigations and audits.
Hi, good morning, commissioners. Your first item is investigative matter A. This is audit number X 2023-101. This was a routine audit in which the respondent's sales transaction files were audited. The respondent had only 3 transactions in the past 12 months. One of the transactions was a sale that the respondent acted as an exclusive agent, single agent listing broker for 2 clients who were both licensed Colorado real estate brokers that were acting as wholesalers on a property they didn't own but had POAs from the true owner of the property. The wholesalers were unrelated to the true owner and didn't disclose their license status to either the respondent or the owner. The respondent's services mainly involved listing the property in the MLS as he never visited the property or communicated with the true owner. The respondent was aware the wholesalers had entered into a purchase contract for $200,000 with the true owner prior to the respondent listing the property. The respondent's transaction file for the sale had missing docs that were later provided, but he didn't retain an earlier offer presented from the buyer. The property was originally listed for $250,000 and subsequently lowered to $209,000 when a $180,000 offer was presented to the wholesalers. The MLS reflected the contract being accepted immediately, but it was not actually signed by either party until September 27, 2023. The property closed for $100,000 less than it was originally listed for and $55,000 less than the wholesalers originally contracted with the true owner. Possible violations include 12-10-2171K, failure to maintain files for 4 years, 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy incompetent practice, and 12-10-4041B and C, single agent duties and obligations. Rule 6.2 competency and Rule 6.20 transaction file requirements. Recommended disciplinary action includes diversion, a fine of $5,000, coursework and ethics, and a license downgrade for 2 years with a high level of supervision. And myself and investigator Jay McLean are here to answer any questions you may have.
Thank you. Anybody have any questions? Okay, hearing done, may I get a motion?
I move to accept staff recommendation.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes as presented. Thank you.
All right, your next item is investigative matter B. This is complaint number 2023-2505. This complaint was opened as a result of audit number X 2023-101. The respondent, along with another licensed broker, obtained a power of attorney from a property owner to carry out a wholesale transaction as the seller. The respondent signed an as-is purchase contract of unknown origin with the property owner for $200,000 on June 1st, 2023. On June 6, 2023, he convinced the owner to execute a power of attorney. On June 15, 2023, he then signed an exclusive right to sell with a listing broker for $250,000. The respondent did not inform either the property owner or the listing agent of his Colorado real estate license status. On July 3rd, 2023, he signed an amend extend to ultimately lower the price to $209,000. Then on July 25th, 2023, a $180,000 offer was presented. On September 28, 2003, the respondent convinced the property owner to amend their contract from $200,000 to $145,000 solely in an effort to secure his assignment fee, which after closing was approximately $27,000. The property closed for approximately $105,000 less than it was originally listed for and approximately $55,000 less than the respondent originally contracted with the owner. Possible violations include 12-10-2171B, making false promises to influence, 12-10-2171C, deliberate misrepresentation, false promise, 12-10-2171M, violation of any commission rule, 12-10-2171W, dishonest dealing, and Rule 6.17, duty to disclose conflict of interest and license status. Recommended disciplinary action includes a final agency order, public censure, revocation, and a $10,000 fine. And again, investigator Jay McLean or myself are here to answer any questions you may have.
Great, thank you. Any questions or comments for the investigators? Hearing none, may I get a motion?
Motion to accept staff recommendation.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes as presented.
All right, your next item is investigative matter C. This is complaint number 2023-2504. This complaint was opened as a result of audit number X 2023-101. The respondent, along with another licensed broker, obtained a power of attorney from a property owner to carry out a wholesale transaction as the seller. The respondent signed an as-is purchase contract of unknown origin with the property owner for $200,000 on June 1st. On June 2nd, 2023, he convinced the owner to execute a power of attorney. On June 15, 2003, he then signed an exclusive right to sell with a listing broker for $250,000. The respondent did not inform either the property owner or the listing agent of his Colorado real estate license status. On July 3rd, 2023, he signed an amend extend to ultimately lower the price to $209,000. Then on July 25th, 2023, a $180,000 offer was presented. On September 28, 2003, the respondent convinced the property owner to amend their contract from $200,000 to $145,000 solely in an effort to secure his assignment fee, which after closing was approximately $27,000. The property closed for approximately $105,000 less than it was originally listed for and approximately $55,000 less than the respondent originally contracted with the owner. Possible violations include 12-10-2171B, making false promise to influence, 12-10-2171C, deliberate misrepresentation, false promise, 12-10-2171M, violation of any commission rule, 12-10-2171W, dishonest dealing, and Rule 6.17, duty to disclose conflict of interest and license status. Recommended disciplinary action includes a final agency order, public censure, revocation, and a $10,000 fine. And again, investigator Jay McLean or myself are here to answer any questions you have.
Thank you. Any discussion? May I get a motion?
Motion to accept staff recommendation.
Thank you. Do I have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes as presented.
Your next item is investigative matter D. This is complaint number 2023-1199. On June 20, 2003, the complainant filed complaint number 2023-1199 against the respondent. The complainant entered into an exclusive right to sell with the respondent to list and sell the complainant's house in Montrose. The exclusive right to sell included a contingency that the seller could cancel the contract if she could not find a replacement property in Denver. Only 3 days after executing the exclusive right to sell, an offer was presented and a counterproposal was executed. However, the counterproposal did not include the seller's contingency provision that was listed in the exclusive right to sell. The complainant alleges that a few days after the counterproposal was executed while visiting Denver, attempting to search for a new property, she called the respondent stating that she could not find a property in Denver and requested to terminate the contract, but alleges that the respondent told her she could not or she would be sued by the buyers. The respondent denies that this took place and there's no written documentation to support that the complainant did request to terminate the contract. Various documents provided conflict with the seller contingency provision and that the complainant stated that she needed to sell her home in Montrose before she would be able to purchase a home in Denver. Possible violations include 12-10-2171Q unworthy and incompetent practice, and recommended disciplinary action includes a dismissal with a letter of concern, and I can answer any questions you may have regarding this complaint.
Thank you. Any questions or discussion?
I thought that the letter was extremely lenient, and I think a fine of $2,500 in diversion would be more appropriate. The contingency was not in the contract, but it was in the exclusive right to sell, and the agent didn't put it in the contract, and I think should be responsible.
Is there any other discussion?
I didn't see any correspondence in any of it that requested that after the exclusive right, and it closed well before then. I did not see that.
Eddie, can you kind of give us an idea of why staff thought that this dismissal with letter of concern was the best course of action?
Sure. So originally this case was closed for what division staff felt was insufficient evidence. The complainant had followed back up with division, expressing concerns over the review that was performed and the outcome of the investigation. So we opened it back up, took another look at it, wrote the report, and as presented, there's conflicting information between the complainant and the respondent. The seller contingency was in the exclusive right to sell. The property went under contract fairly quickly, only a few days later, and the complainant had stated in a few different on a few different occasions in a few different letters that they could not have a contingency while they were looking for their home in Denver, or else they wouldn't be able to purchase a home. So although it was originally in the exclusive right to sell, there was nothing in writing indicating that they wanted that in the counter proposal. And there was, like I said, there was conflicting information alluding to the complainant not wanting that contingency because of their situation and trying to purchase a home in Denver. In speaking with the respondent and speaking with another witness, they all deny that they were told the complainant wanted to terminate the contract or wanted to get out of the contract. The respondent denies telling the complainant that she was going to be sued. So it really was kind of a insufficient evidence to truly prove that the complainant did ask to terminate the contract and the respondent told them they could not. The reasoning behind the violation and the recommendation here is because the general, maybe they should have put this into the counter proposal simply because it was in the exclusive right to sell. But again, there's a lot of conflicting information behind it. This respondent has indicated that they are closer to retiring. And so staff felt that this recommendation was appropriate given kind of their course of employment and, you know, where they're heading in the future.
So Eddie, I don't remember, was that actually in writing from the complainant that they didn't want the contingency in the contract due to the purchase in Denver? Or
No,
was
so
that
there
nothing-
was nothing specific saying I don't want it in the counter proposal, but in the demand letter that was sent to the respondent, they indicate that she could not have the seller contingency in trying to purchase her home in Denver. She also told myself and the other investigator the same thing
Okay,
in interviews with her, that while she was looking for a home in Denver, her real estate broker in Denver told her you cannot have a contingency while trying to purchase a home in Denver. You're gonna miss out on these properties.
okay, well then I'll recant what I said and I'll agree to staff recommendation.
All right. Before we do a motion, was there any other questions or comments for the investigators? Seeing none, may I get a motion?
All right, I motion to approve staff recommendation.
Second?
Second.
Thank you. Any further discussion? All those in favor? Aye.
Aye?
Aye.
Any opposed? Motion passes as presented.
Good morning, Commissioners.
Morning.
The next is complaint matter E. It's complaint number 2023-1654. The complainant alleges that the respondent listed a property in the MLS without having a valid exclusive right to sell listing contract with the sellers, as the listing contract was not executed by the parties. The investigation found that the respondent listed the property on the MLS for nearly 1 year without an executed contract. The respondent also amended the list price 4 times without appropriate documentation, and none of the documents in the transaction file had been executed. Possible violations include 1210-217-1Q, 1210-217-1M, 1210-4082B, and Rule 6.14C. Disciplinary recommendations include coursework and brokerage relationships, coursework and contracts, diversion, and a $1,000 fine. And Investigator Gabarty can help answer any questions.
Okay, thank you. Questions or comments?
So I know we had emails regarding the price changes. Was there also emails regarding the listing contract as far as approving it? I know it wasn't signed. Were there emails that were approving it? And the disclosures weren't signed either. So do you remember if we had emails approving them, just not actual signatures?
In speaking with the respondent, she stated that she received confirmation from the sellers that they had signed the exclusive right to sell listing contract. And although she didn't confirm indeed that they had, she took their word for it.
Does that go with it as also with the disclosures?
The disclosure she didn't really speak to, just with regard to the exclusive right to sell listing contract, that they had confirmed that that had been signed. So she took their word for having signed the documents, and she just ran with that.
Okay.
Any other questions? Hearing none, do we have a motion?
I move to accept staff recommendation.
Do we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes as presented.
Matter F is complaint number 2023-585. The complaint alleges that several real estate brokers who are not licensed in Colorado listed a commercial property with the assistance of the respondent, who is licensed in Colorado to practice real estate. The allegation could not be substantiated. However, the investigation found issues with the respondent's failure to establish a required brokerage relationship, as well as issues with his transaction documents, including the retention of and closing responsibilities. Possible violations include 1210-217-1M, 1210-408, 1210-217-1K, Rules 6.6, 6.19, and 7.1. Disciplinary recommendations include coursework and contracts, diversion, and a $500 fine. And again, Investigator Gabarty is here to answer any questions.
All right, any questions on this one?
I think the fine should be increased on this one. We have multiple issues having to do with disclosures, the broker's relationship, amendments, not using real estate forms, settlement statements not signed, et cetera, et cetera. So I would vote to increase the fine to at least $2,500.
Do we have any other discussion or alternate thoughts about what Renee has suggested?
I feel like some education on the forms would be reasonable. There was a lot that was missing on this. Would that be something that could be considered?
It looks like they're saying coursework and contracts.
Oh, I did see coursework on that. Well, I think that that was probably the most important thing for me.
Okay. And do you have any thoughts of increasing the fine?
I think Commissioner Lin's recommendation is reasonable.
All right. I agree, Renee. I think there were a lot of issues on this one. Would you like to make a motion?
Sure, I move to accept staff recommendation with changing the fine to $2,500.
We have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes with the amended fine of $2,500.
Matter H is complaint number 2024-324. The complainant, who was the seller of the property, alleged that the respondent, who represented the buyers, shared the property's access information with several third parties without authorization from the complainant or the listing broker. The complainant explained that after the home inspection, the respondent provided the access information to several tradespeople for further inspection of various areas of the home. The respondent failed to draft and amend extend, changing the earnest money amount provided by the buyers. Possible violations include 1210-217-1M, 1210-217-1Q, and Rule 6.16. Recommended disciplinary action is diversion and $500 fine. And again, Investigator Gabarty is here to answer questions.
I just have a quick question. What happened to G?
I think we've skipped ahead.
Oh,
Nicole, you just introduced matter H.
sorry
So-
about that.
That's okay. We'll do H and then go back to G. Just try to see if we're awake.
Nicole's trying to keep everyone on their toes today.
Uh-huh.
Right?
Okay.
Make sure everybody has their caffeine.
Thanks
All
for
right.
bringing that up.
Do we have any questions or comments on matter H?
I actually thought the fine should increase, and the reason is that there was such a vehement denial that this was done. There wasn't any ownership of this. Unless I'm looking at the wrong, I'm looking at the wrong one. Let me, yeah, no, wait a minute. Oh no, this wasn't the denial one, sorry. But I still thought the fine should be increased because there was no communication with the other agent regarding accessing the property. And I think it's pretty, common knowledge that you need to let them know when you're going to be in and out of a property. So I would vote to increase the fine to 1,000 instead of 500.
Anyone else? All right. I agree, Renee. I agree with you. Do you want to make a motion?
Sure, I motion to, well, let me think, staff recommendation. Well, I motion to, on this one to do diversion and a fine of $1,000.
Do we have a second?
Second.
Thank you. Any further discussion?
Aye. Oh,
All
sorry.
All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes with the fine increase of $1,000.
You got thrown off because we skipped G here.
Renee, that's usually me who skips over part of that.
I'm sorry about that. Okay.
It's okay.
Matter G is complaint number 2023-2541. The complainant, who was the buyer in a transaction, alleges that the respondent, who was the buyer's agent, failed to advise the complainant to obtain expert advice as to material matters, specifically mediation. Additionally, the complainant alleges that the respondent failed to obtain the assistance of an employing broker, supervisor broker, or legal counsel, as the respondent stated she had, regarding the request for mediation with the sellers. The complainant also requested transaction documents that were not provided by the respondent. The investigation found that the respondent failed to establish a brokerage relationship with the complainant until the date of closing. Possible violations include 1210-217-1M, 1210-217-1Q, 1210-4082B, Rules 6.25, 6.5, and 6.24. And the recommended discipline is a public censure, a final agency order, a fine of $3,000, coursework in brokerage relationships, coursework in ethics, and a high level of supervision for 2 years if the license is reinstated. And Investigator Gabarty can answer any questions.
Thank you. And there has been no request or anything regarding reactivating the license as of today?
That's correct. As far as I know, I'm going to look up her name real quick. Nothing has changed on that end.
Okay. Thank you.
Sure.
Anybody else have any questions or comments? Right, hearing none, may I get a motion?
I motion to accept staff recommendation.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Okay, now we're back to matter I, complaint number 2024-193. On April 20th of 2022, the respondent pled guilty to Class 1 misdemeanor assault 3, no reckless cause injury. She was sentenced to 2 years supervised probation that has since been amended to unsupervised, with various substance evaluations, treatment, and $1,044.50 in court costs and fees. They have been paid in full. On December 6th of 2023, she subsequently pled guilty to a Class 1 misdemeanor protection order violations criminal. She was sentenced to 12 months of supervised probation with various substance evaluations, treatments, and $894.50 in court costs and fees that are past due. The respondent failed to submit a written response and requested documents to the commission in connection to the charges as stated in the notification letter. Possible violations are 1210-217-1M, 1210-217-1N, 1210-217-1P, Rules 6.23 and 6.25. Disciplinary recommendations are diversion, a $1,000 fine, probation concurrent with the criminal sentence if the license is reactivated, and the fines must be paid in full prior to reinstating her license. And Investigator Gabarty is here to answer any questions.
Great. Questions, comments? May I have a motion?
I motion to accept staff recommendation.
Second?
Second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter J is complaint number 2023-1566. The investigation found that there were numerous errors in preparing and managing contract documents. Possible violations include 1210-217-1Q, 1210-217-1M, Rules 6.5, 6.9, 6.14C, and disciplinary recommendations are diversion, a $500 fine, coursework in brokerage relationships, and coursework in contracts. And Investigator Peters can answer any questions that you might have.
I thought the recommendation was good, given that there was some compensation involved in this case from the agent.
Any other comments or questions? Seeing none, may I get a motion?
I motion to accept staff recommendation.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Matter K is complaint number 2023-1650. The complainant purchased a property that was listed by the respondent. The complainant alleged that the respondent had documentation from a plumbing company indicating that the sewer line needed immediate repair. However, the documentation was not provided to the complainant prior to closing as agreed upon in the inspection resolution. Possible violations include 1210-217-1Q, 1210-4041B, 1210-217-1M. Disciplinary recommendations are public censure, a final agency order, a fine of $1,000, coursework in contracts, and coursework in ethics. And Investigator Peters can answer any questions.
Again, normally I would think this fine would be low, but we had some other money that transpired based on civil court, etc., outside. So I'm thinking this might be okay.
I agree, Renee. Anybody else have any questions or comments?
No, I agree with that.
The inspection was a little odd, the inspection resolution, because it has the listing agent being a party to the contract on that. That was a little odd. But if we're okay, you want me, I'll motion to accept staff recommendation.
Great. We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes as presented.
Matter L is complaint number 2024-194. On December 1st, 2023, the respondent pled guilty to assault 3, no reckless cause injury, a class 1 misdemeanor. The respondent was ordered to pay $841.50 in court costs and fees. There's a remaining balance of $316.50. The respondent was ordered to complete 12 months of supervised probation, which is ongoing. Possible violations include 1210-217-1N, 1210-217-1P, 1210-217-1M, and Rule 6.23. Disciplinary recommendations are diversion, a fine of $500, and probation to run concurrent with a criminal sentence. And Investigator Peters can help answer any questions.
And this license is still inactive.
I'll double check real quick.
Yeah, I was just gonna say at the time, excuse me, at the time of the report it was, and it sounded like you did not have an interest in making it active again, but I appreciate you looking it up, Nicole.
He's still inactive.
Any other questions or comments? May I have a motion?
I motion to accept staff recommendation.
Second?
Second.
Thank you. Any other discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Matter M is complaint number 2023-1616. The investigation found that there were potential violations concerning the preparation of contract paperwork. Possible violations include 1210-217-1M, 1210-217-1Q, Rules 6.5, 6.6, 6.14C. Disciplinary recommendations include diversion, a $1,000 fine, coursework in brokerage relationships, and coursework in contracts. And again, Investigator Peters can answer any questions.
So I thought the coursework is good, but there were so many violations related to the contracts and paperwork. I thought we should increase the fine to $2,500.
I agree. I mean, the respondent has had a license for a very long time. And should know better. Right. I don't know how else to say that. Should know better. So I agree with the fine. Erica, Autumn, do you have any thoughts on that, or does that fine work for you?
I agree. I think the fine should be increased.
Yeah. Agreed.
All right. Renee, would you like to make a motion?
Okay, I motion to accept staff recommendation with the change of the fine being increased to $2,500.
Second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes with the fine increase up to of 2,500.
Matter N is complaint number 2023-2409. The investigation found that the respondent did not obtain an executed brokerage duties addendum to property management agreement with the landlord or an executed radon disclosure to tenant form. Possible violations include 1210-4082B, 1210-217-1M, 1210-217-1Q, and Rule 6.5. Disciplinary recommendations are coursework in brokerage relationships, diversion, and a $500 fine. Investigator Geske can answer any questions for you.
So I would say this one is similar. We're missing a couple major disclosures as far as the brokerage disclosure and the radon disclosure. And I would vote to increase the fine to $2,500.
And I don't remember, there wasn't an audit, right? Because they manage 145 doors.
This wasn't an audit. This was just an investigation.
Okay. So we don't actually know if they're doing radon or that for all of the
No.
leases they have. I apologize, Renee. What were you looking for the fine?
I would increase it to $2,500.
Any other questions or comments? Hearing none, may I get a motion?
I motion to accept staff recommendation with the change of increasing the fine to 2,500.
We have a second.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes with the increase of fine to 2,500.
All right. Matter O is complaint number 2023-71. The complainant seller's agent alleged that despite explaining explicitly to respondent to quit communicating with his seller, the respondent engaged in sign crossing by entering into a listing agreement with the complainant's seller. The investigation noted the additional potential violations that the respondent failed to timely establish his brokerage relationship to the seller, failed to timely change his brokerage relationship with the buyer, and failed to sign off on the settlement statement. Possible violations are 1210-217-1M, 1210-217-1Q, 1210-4082B, Rule 6.5, 6.15, and 6.19. The disciplinary recommendation is diversion, a fine of $2,500, and coursework in brokerage relationships. And investigator Denise Wright is here to answer any questions you may have.
And this license is inactive.
Yes, correct.
Because this is similar to a different, this is connected to another matter, correct?
Yeah.
Okay.
It is, yeah, it's connected to matter Q.
Okay. All right. Any other questions or comments? Hearing none, may I get a motion?
I motion to accept staff recommendation.
All right, do we have a second?
Second.
Do we have any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes as presented.
All right, matter P is complaint number 2022-1952. Complainant, who is respondent's former employing broker, alleged that while acting as a listing broker under seller agency, respondent began representing the buyer under buyer agency, thus creating dual agency. Complainant further alleged that respondent authorized the buyer to move into the vacant property prior to closing and collected $1,775, which he deposited into his own personal bank account. Complainant alleged that the respondent failed to have the buyer and seller enter into a written pre-occupancy agreement or rental agreement. Finally, when the buyer had a survey of the property, it was discovered that there was an encroachment. Complainant alleged that the respondent failed to file an objection or move the deadlines, which caused the buyer to forfeit their $4,000 earnest money deposit. The investigation also noted the potential violation that the respondent failed to respond to the Commission's multiple requests for response to this investigation. Possible violations include 1210-217-1B, 1210-217-1M, 1210-217-1G, 1210-217-1H, 1210-217-1I, Rule 5.2, Rule 5.7, and Rule 5.9. And then there's additional violations down in notes, which is statute 1210-217-1K, 1210-217-1Q, 1210-217-1W, 1210-404-1B, 1210-405-1B, and 1210-406. The disciplinary recommendation is a final agency order, public censure, revocation, and a fine of $37,500. And investigator Deemies Wright is here to answer any questions you may have.
Thank you. Questions or comments? Hearing none, may I get a motion?
I move to accept staff recommendation.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
All right, so matter Q is complaint number 2023-114. Complainant alleged that the respondent, the employing broker of respondent on a previous complaint, in this case it's matter O, failed to supervise the respondent by allowing and encouraging him to engage in sign crossing. Respondent's supervisee had less than 2 years of experience at the time of the transaction. The complainant seller's agent alleged that despite explaining explicitly to respondent's supervisee to quit communicating with his seller, the respondent engaged in sign crossing by entering into a listing agreement with the complainant's seller. The investigation revealed that the respondent failed to confirm statements made by the seller that she no longer had an active agreement with the complainant. In addition, respondent failed to timely review his supervisee's transaction documents to ensure that they had timely established their brokerage relationship to the seller, failed to timely change his brokerage relationship with the buyer, and failed to ensure that someone from the brokerage signed off on the settlement statements. Possible violations are 1210-217-1M, 1210-217-1Q, 1210-217-1R, Rule 6.3, Rule 6.15, Rule 6.19. And the disciplinary recommendation is diversion, a fine of $2,500, and coursework in supervision. And investigator Deemies Wright is here to answer any questions you may have.
What's the coursework and supervision? Is that just the broker's course again? The employing broker course? Do we have a specific course for that?
Yeah, it would be just a course in being an employing broker and supervising, and there are courses for that, yes.
Okay.
Any further questions or comments? Hearing none, may I get a motion?
I move to accept staff recommendation.
Second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Complaint number 2023-2102 is matter R. The complainant was the listing agent for the property. The respondent scheduled a showing for the property. The listing agent alleged that the respondent provided the lockbox code to a buyer. The respondent provided a written response denying the allegation and stating it was false. The respondent was interviewed, and during her interview, she denied providing the lockbox code to her buyer's mother. After the respondent was interviewed, a Ring doorbell video was provided to the Division of Real Estate, which shows the respondent's buyer's individual arriving at the property without the respondent. As the buyer's mother was approaching the front door, another showing was finishing. The video provided shows the buyer's mother repeating the lockbox code out loud. This incident was being observed by live video through the Ring doorbell. The buyer's mother never gained access to the property on her own. Ultimately, the listing agent went to the property to conduct the showing. The respondent was provided a copy of the video and was then re-interviewed. The respondent did not have a buyer's agreement with this buyer client. Possible violations are 1210-217-1M, 1210-217-1Q, 1210-217-1C, and Rule 6.16. Disciplinary recommendation is a final agency order, a fine of $1,500, coursework in ethics and coursework in brokerage relationships, and Investigator Coates is here to answer any questions you may have.
Thank you. Questions or comments?
So this is the one that I thought the fine should be increased to 2,500 because it was denied, and it wasn't until the Ring doorbell was provided that it was kind of like, oh, okay, you got me. So because of that, I thought the fine should be increased.
To 2,500.
Yes.
Anybody else have any questions or comments or have any trouble with that fine?
No, I don't have any trouble with that. I agree with Commissioner Lind on that assessment.
Same.
All right. Would you like to make a motion?
Sure, I move to accept staff recommendation with the change of the fine being increased to 2,500.
All right, a second.
Second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes with the fine increase to 2,500.
All right, matter F is complaint number 2023-176. The division received a complaint from the buyer who purchased the respondent's listing. She stated that she purchased the property based on misrepresentations made by the respondent. Part of the respondent's buyer's packet, which was given to at least 3 potential buyers, outlined income potential for which the property was not zoned. The document did not indicate anywhere that a special variance would be required to use the property in the way described. The respondent failed to provide the complainant with information relevant to the physical condition of the property that he had learned from a previous contract. The respondent counseled the sellers to remove an item of disclosure on a revised seller's property disclosure. It was a disclosure made to previous buyers but excluded from the complainant at the time of her purchase. Possible violations are 1210-217-1A, 1210-217-1Q, 1210-404-3A, 1210-217-1M, Rule 6.2. Disciplinary recommendation is diversion, a fine of $2,000, and coursework in rural properties. And Investigator Hardy is here to answer any questions you may have.
Thank you. Questions? Yeah.
This was one too that I wasn't sure about the fine. I have mixed feelings about increasing it. The person buying it seemed like they had extensive knowledge of the area and properties around there dealing with the rural properties. However, the selling agent clearly didn't provide multiple things nor check out things that were being handed out. I don't know. Michelle, do you have thoughts on that one?
Well, I mean, I think, something that's consistently, kind of drilled into like the annual update is understand your area, right? So I'm wondering if there is, I don't remember if this person is familiar with dealing with these kind of properties.
It didn't sound like much. He was asked to do it, I believe, but did not have the knowledge you would normally expect on a property like this.
And they are an employing. I would like to see, I don't know what kind, I would like to see some additional education. I don't even know what that would look like.
Yeah, unless you do contracts again, but I mean, it's got rural properties. But yeah, what else would you do besides contracts? Anyone else have any ideas? Income properties? I don't, but that in this situation, it's a different type of income property, but it still is an income property. I don't.
Yeah, and the issue came down to, well, one of them was the income potential and then the zoning that was there.
Mhm.
Sarah,
I'm
have you seen any other type of education that people would take who are trying to gain knowledge from, in certain areas that they're doing business in? That would be of assistance, or is it the rule just kind of covering that?
Yeah, I think I was trying to cover it just with the like a class on rural properties. I would have to look and see if there's one maybe specific to zoning potentially. The other one you could do is not because of the income, but because of the other issue, you could do, disclosure of adverse material facts. But hopefully the rural property class, and that's a pretty general one. There's a lot of, classes on rural properties we can probably find. So
Can we do hours?
Yeah, that's what I was thinking, more hours, because it's not saying how many hours.
Yeah.
So, and what, do we know what a normal class is on rural? Is it 3 or 4? We could do 12?
I would say more like 6 hours of some type of education. Is that possible, Sarah? Is that something you think that they would be able to accomplish?
I think
I
so,
don't want
yeah.
to tie their hands and have them be in, violation of it, but I also don't want to limit them from trying to learn something different to expand their knowledge base of what they're working on. So,
Yeah, I think you could
Or
do.
establish a floor for us, and then that way, if you say no less than 6 hours and there's only a 4-hour class, then they can take maybe 2 different rural property classes and hopefully gain a broader knowledge of the issues.
okay. I like the 6 hours. I think that should at least give some good basis for that. I don't know. Renee, what are your thoughts?
So just do the classes, not leave the fine where it is, or do we change the fine?
I'm
Right
okay with I'm okay with the fine.
Okay.
Let's see.
It's-
Commissioners, what do you think?
I'm okay with the fine. I like the idea of the coursework, and I mean, I don't know if they can say rural properties and zoning, just spread it out a little bit so that they can do a combination of that, because zoning to a large degree takes care of encompassing some of the ruralness of that.
Yeah, I can add that.
So are we adding zoning? Are we just saying 6-hour rural? Or are we going to do 3-hour zoning?
Can we? I think we're making it harder than it has to be.
Okay.
Right, no less than 6 hours of coursework in rural properties, and zoning or
Yeah.
zoning.
I think that's a good idea.
Okay.
Are we okay with that?
Yep.
All right. Can we get a motion?
Now I motion to accept staff recommendation with the clarification that it is 6-hour coursework for rural and zoning.
Second?
Second.
Yep. Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes with the amendment of the hours on coursework.
All right, matter T is complaint number 2024-453. On March 4th, 2024, the respondent self-reported a conviction of assault and threatening a person in Denver County Court. The conviction stems from an incident on July 4th, 2023. The respondent was found guilty of threatening and the assault of a contractor who he believed was taking too long to complete a kitchen remodel. Possible violations are 12-10-217-1N. The disciplinary recommendation is diversion and a fine of $250. And Investigator Levy is here to answer any questions you may have.
Any questions, comments? May I get a motion?
I motion to accept staff recommendation.
A second?
Second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes as presented.
All right. Matter U is complaint number 2023-1353. The complainant alleges that the respondent signed electronically her name on the lease 3 days after the complainant left the company. CREC alleges the respondent, the owner of the property of a property management company, in the course of operating her property management business, commingled and diverted security deposit funds, moving at least $50,000 into her business operating account with no documentation or explanation, improperly marked up maintenance invoices, maintained negative ledger balances, failed to maintain records, failed to produce records, advertised under a company name other than her own, and violated a lawful commission order. The respondent also owns the maintenance company in question and is currently required to be under a high level of supervision pursuant to a previous stipulation and final agency order. Possible violations are 12-10-217-1M, 12-10-217-1H, 12-10-217-1I, 12-10-217-1K, 12-10-217-1M. And then continued on page 2, 12-10-217-1Q, 12-10-217-1T, 12-10-217-1W, 12-10-404-1B, 12-10-404-1C6. And then back to page 1, Rule 5.1, 5.9, 5.10, 5.15, 5.17, 5.14, 5.21, 6.10, and 6.25C. The disciplinary recommendation is a final agency order, public censure, revocation, and a fine of $45,000. And Investigator Rickay is here to answer any questions you may have.
Questions or comments? May I get a motion?
Motion to accept staff recommendation.
Second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Investigative matter B is complaint number 2023-2517. The respondent appears to be operating an unlicensed property management company in Boulder, Colorado. The owner of the company seemed unaware of their non-compliance and believed they were operating under a licensed employing broker. The possible violation is 12-10-202. And the disciplinary recommendation is a referral to the Attorney General where they can send a warning letter. And Investigator Rickay is here to answer any questions you may have.
What does that warning letter kind of say? Can we just have a quick overview of what it says?
Well, it hasn't been drafted yet. But typically what happens with unlicensed practice cases is we file an action to enjoin that activity. And so this would be a step short of actually filing the lawsuit for an injunction. It would be a warning saying, you know, in our view, there is a license law violation here. You're not licensed to practice. And so, you know, if this conduct doesn't cease, then the injunction would be the next step, something along those lines.
And does that give them a time period to respond back, or is it just an open letter?
Likely, yes. And if we had to come back to you and ask for the authority to file an injunction, we would probably do that at your August meeting, perhaps.
Okay, thank you.
We also had the issue where the rent security deposit were in the same account. Same bank account, correct? That's what-
Yes, that's correct.
Okay.
Okay.
So does that doesn't warrant something stronger than a letter on that case, or it's because it's unlicensed?
It's because it's unlicensed.
Okay.
You're correct. Commissioner, you're correct. Yes.
Okay.
All right, any other questions or comments? Hearing none, will we get a motion?
I move to accept staff recommendation.
Second,
Second,
any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes as presented. So before we move on to licensing matters, do we want to just push through, or do we want to take a break, like a 10-minute break?
If we can take a break, that'd be helpful for my bladder.
All right, so let's call it 10:15. Let's come back at 10:25.
Okay.
Sarah Espinoza, before the commission moves on to licensing matters, can I ask a clarifying question of the team lead on one of the investigative matters?
Sure.
And Sarah Halloran, I don't know if you're back on. Thank you. Sarah, for investigative matter P, was one of the possible violations in that one Rule 6.25? I didn't hear it, but it could be that I missed it.
Yeah, thank you. I had gotten notification of that as well. Yeah, 6.25 is also one that needed to be added.
Thank you.
I think we're just waiting for, there she is. All right, we are on to licensing matters.
Licensing matter A is an application, complaint number 2024-774. On May 2nd of 2024, the applicant submitted an application for an employing level real estate broker, disclosing that her Georgia real estate broker's license had been disciplined in 2006. She explained that during a routine audit conducted by the Georgia Real Estate Commission, it was found that she had converted her signature into a JPEG format that would then be affixed to documents by herself and staff. The Georgia Real Estate Commission found that her brokerage failed to ensure that only licensed personnel performed those acts that required a license. Additionally, the Georgia citation noted that she became party to the falsification of contracts by allowing other people to sign her name as the listing agent. We do not have a recommendation as usual.
Okay. Do you have any questions or comments?
Comment is she doesn't live here, and she now has 2 other states that are inactive. It doesn't really say why, but she's got a couple others that are inactive. So it just sounds like she's getting referrals, but
She does have a lot of active though. So do we have a motion? I mean, the applicant is active in quite a few states. And if this is the only discipline that we're seeing, and it was from so long ago, I don't see a problem with full approval on this one.
Those are my thoughts, Michelle.
Anybody else?
I agree, Michelle. That's a good assessment.
All right, do we have a motion?
You gonna try to get the language down, motion to approve?
Okay.
Yes.
I
So,
motion to approve staff recommendation.
well, there's a staff recommendation on this one. We either
it's
have
application.
to. Yep, it's an application. So
Oh,
we're
yeah, they're not recommending on these.
so it'd be approval of application for licensure.
I motion to approve application for licensure.
All right, and thank you. And Autumn, you did the motion for me. Thank you. All right. Any further discussion? All those in favor?
Aye.
Aye. Any opposed?
Aye.
All right, motion passes with 3 approval ayes.
Matter B is an application, complaint number 2024-630. The applicant received a letter of admonition on February 9th of 2024 from the Colorado State Board of Nursing due to her failure to meet her obligation as a mandatory reporter under section 19-3-304 CRS. And we do not have a recommendation. Investigator Gabarty can answer any questions that you might have.
All right, any questions for the investigator?
No, I thought this one was fine. There was lots of documentation and paperwork supporting things, and I thought it looked good.
I agree. It was pretty straightforward.
Do we have a motion?
Yeah, motion to approve application. Oh, the preliminary, positive. Motion for positive preliminary advisory opinion.
It's an application.
Is it up? Oh, I'm looking at C. Sorry. Okay, motion to approve application for licensure.
All right, we have a second.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes for full approval.
All right, licensing matter C is complaint number 2024-566. This is a preliminary advisory opinion. On December 4th, 2018, the applicant was convicted of a Class 1 misdemeanor, assault 3, knowingly and recklessly causing injury. The applicant was sentenced to 18 months probation and a fine of $293.50. The applicant has completed probation and has paid the fine in full. The case is closed. On March 1st, 2021, the applicant was convicted of a Class 3 misdemeanor, criminal mischief under $300. The applicant was sentenced to 6 months probation and a fine of $343. The applicant has completed probation and has paid the fine in full, and the case is closed. As usual, there's no recommendation, and Tabitha Quinton is here to answer any questions you may have.
So it looks like all the recommendation letters were from when this person went to court in 2020. Doesn't look like there's anything new since then. Anything dated recently or after they've been on, I don't know, was it probation or whatnot. So we don't have anything new. It all is pertaining to, looks to me to be the court case when they went to court. So I would like to see something recent about their behavior since then.
I think that's totally reasonable and something that's kind of been in line with what we've asked for in the past. Is some letter of recommendations, yeah, that are current and verified.
And commissioners, did you want to defer this one to your next meeting so that the investigator could try to obtain those additional materials? Or it's a preliminary advisory opinion. You could deny it. They could resubmit another PAO or an application with those materials. It's your preference.
I think we should do a negative opinion, and with the reason that we need updated current letters of recommendation, we want to know what's happened in the last 4 years.
I agree. Commissioners,
I agree. That seems very reasonable.
Seems reasonable.
All
Okay,
right.
so we're gonna we're gonna do a negative preliminary advisory opinion with a clarification that we do need updated current letters of recommendation. We want, not sure how you want to do that. We want information in the last 4 years since the last court case.
Okay, do we have a second?
I'll second.
Thank you. I think I heard Autumn first. Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
All right, licensing matter D is an application. It's complaint number 2024-664. On October 26, 2023, the applicant was convicted of harassment, follow person in a public place, a Class 1 misdemeanor. The applicant was sentenced to a 24-month deferred sentence. The deferment was revoked and he was resentenced to 3 years probation and a fine of $276.50. The applicant's deferred sentence is still ongoing and is set to end in 2026. The applicant has paid the fine in full and is in good status with probation. On June 1st, 2023, the applicant was convicted of harassment, follow person in a public place, a Class 1 misdemeanor. The applicant was sentenced to a 3-year deferred sentence and a fine of $341.50. Applicant's deferment is in good standing with probation and the fine has been paid in full. And both of these cases are concurrent discipline. There is no recommendation, and Investigator Quinton is here to answer any questions you may have.
So I'm confused as to why the person is applying now, since we don't normally have people on probation. The probation's not up till 2026. So I would say we deny it with, you can reapply after the probation is up in 2026.
I agree with that, Renee.
I had that same question.
Okay, so would someone like to make a motion?
Well, I motion to deny the application for licensure. And I don't know if we want to put a clarification on there that they're welcome to apply after probation is up in 2026.
We'll need to give a reason for denial.
Okay. So the reason would be because the probation is ongoing at this point and would like they can reapply after the probation is done.
Is that sufficient, Angela?
So it's Marcia who keeps track of the bases for your denial. What I hear you saying, Renee, is that they haven't completed their rehabilitation. And I think that's all Marcia needs, but she'll chime in if she needs clarification. And then we do need a second.
Yeah.
Second.
Yeah, basically, I'm hearing the same thing with Angela, that they haven't demonstrated rehabilitation yet.
Okay, perfect. All right, and Erica second for us. Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
All right, licensing matter E is an application. It's complete number 2024-801. On January 14th, 2021, the applicant was convicted of trespass of a dwelling, a class 5 felony, and a class 3 misdemeanor harassment in convenient hours. The applicant was sentenced to 4 years deferred sentence and 2 years probation with a fine of $549. The applicant's deferment and probation are ongoing until January 14th of 2025, and the fine has been paid in full. As usual, there's no recommendation, and Investigator Quinton is here to answer any questions.
So this one would be similar, in my opinion, that the rehabilitation is not correct, is not complete, and also that the letters look to be done for the court date back in 2020.
Okay. So would you like to make a motion?
I motion we deny the application for licensure with the clarification that the rehabilitation has not been complete and the recommendation letters are not current.
Okay, we have a second.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes. We are now on to ESP matters.
Good morning, commission members. Eric Turner filling in for Penny Elder today. The first matter is matter A, which is complaint 2023-1159. The respondent on August 15th signed a stipulation. The basis was being non-compliant with their continuing education. They agreed to a $500 fine plus surcharge and complete 13 hours of elective continuing education. To date, they have not paid the fine or submitted any makeup education. Part of the stipulation in paragraph 12 that they signed does say that failure to comply would result in formal discipline. As such, the staff recommends that you find a violation of 12-10-217-1M, issue a final agency order, public censure, and a fine up to $2,500. And I'm here to answer any questions you may have.
All right, thank you. And
So-
license is still inactive, correct?
And the license is inactive at the date of this report. I did not check this morning if it's still inactive or not.
I apologize, Renee, I cut you off.
That's okay. So on this one, there's been no communication from this person, no response to anything that has been sent out. Is that correct?
No, they have responded. We've actually contacted them many times, and I believe the last communication was on April 9th. And I believe the respondents stated that they could not comply with their commitment.
So if they can't comply or unwilling, just a question as far as they're inactive, would we revoke their license? Doesn't seem like they're wanting to continue.
Well, that is up to the commission on what they want to do. Staff recommendation is the final agency order, public censure, and a fine.
Well, and going, if they were to try to be active again, they would have to pay their fine, correct? Prior to being able to be active?
No, they would be able to activate if they did not comply with that stipulation.
So I
Commissioners,
guess-
I think that's something that you could order. We saw a similar recommendation in one of the complaint matters today. So if that was a concern, if that would address your concern, Renee, that's something that is available to you, I think.
As far as what? As far as making sure that they have complied with the stipulation before they can reactivate?
Correct.
And how would we do that?
We would just add that the fines would have to be paid prior to them reactivating their license.
Well, it's not just the fines, it's the stipulation. It's as far too, which, the money that needs to be paid and the coursework that needs to be taken and the fine.
Right, so we would just put all of those have to be satisfied prior to them reactivating their license.
Okay.
And commissioners, likely what would happen is Penny would send out a new stipulation documenting that they would be inactive until they comply with the terms, and then we will just put a records hold on them in the system that would keep them from activating.
Okay.
Erica, Autumn, I know you didn't see this case prior, but do you have any thoughts on that discipline?
I agree with what Renee is stipulating, and it's good to have that checks and balance before the license renewal.
Agreed.
And just for clarification, commissioners, the original stip was for 12 hours of coursework, not 13.
Okay. Yeah, I just don't think this is something that is, well, I thought the 13 was interesting. I'm like, adding in some flavor there. I just don't think this is something for revocation, especially if they're already inactive. I mean, it was a education violation. And it looks like there were circumstances maybe going on in her life that, so I don't think it goes to the point of revocation. So I think putting that, I don't know why I can't talk today or think, honestly. Putting that stipulation in that they have to meet all those requirements before they can reactivate their license would protect what we're looking to do. Renee, are you okay with that?
Yes. So how would we do this? How do you want this done verbally, Angela? Or because their recommendation, do we just say that the fine of the $2,500 plus the stipulation that was signed on 8/15/23, which is the Well, that's not the fine though in there, because now the fine is 2,500. So the fine of 2,500 and the 12 hours of coursework need to be completed before a license is activated.
That works?
Okay.
You got it. Here's your
Okay.
motion.
Yeah. So two things here, Renee, just to clarify, the recommended discipline is for the violation of the stipulation for diversion. And I think the additional layer that we've talked about is compliance with the terms of the stipulation for diversion in order to reactivate the license. So discipline for violating the stip, requiring compliance with that first step in order to reactivate. I think that'll do it.
My question though is the stip has a dollar amount in it, and now there's an additional dollar amount is how I'm reading it. Is that correct? There's $2 amounts?
Correct. And I do not suggest that you require compliance with your discipline today in order to reactivate. I think compliance with the earlier step is going to be sufficient here. And likely what will happen is when Penny reaches out to this person, assuming, or my office does, we will certainly try to negotiate a surrender of this license. So we'll see.
So the motion, Renee, that you did was fine.
It was.
Yeah. Marcia said it was good, so that's what we needed. But we do need a second. So do we have a second on that motion?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
And the next matter on the agenda is matter B, which is complaint 2023-1912. The license does have an active, or the licensee does have an active license. On January 22nd, the licensee signed a stipulation for non-compliance with their continuing education. They agreed to pay a total fine of $862.50 and complete 24 hours of coursework, which was 6 hours of contract, 6 hours of current legal issues, and 12 hours of electives. To date, they have not complied with either the fine or the continuing education. As such, in the stipulation they signed, failure to comply would result in formal discipline. And staff recommendation is that you proceed with a violation of 1210-217-1M, a final agency order, a fine of $2,500, and public censure.
Maybe this person's license is still active and they could still be using their license where they haven't complied with the stip. And if we're doing this another fine on an FAO, they can still continue using their license. Is that correct?
That is correct.
And just to clarify, it looks like they did pay their fine in March. They just haven't completed the coursework as of the date of this report.
And it seems to me that coursework is an important part of maintaining your license. So if that's not being complied with and the license is still active and it can still be active, we're just going to be chasing this. So my question on this is, why wouldn't we do a revocation? Because they're still active and they're not taking their course, doing coursework.
Because that's a big jump. That's a
Okay,
big jump from.
But what do you do?
Well, if they don't.
But they're still active.
Typically, what we've done in the past and what we've seen is that if they do not comply with this now, because it was diversion before. So if they do not comply here, then we go for revocation. I mean, to go from.
Is there a certain time frame that they're given to do this? They haven't complied, haven't responded, and the license is still active. They're still using it. How long do you give them to comply?
In this case, we gave them until March 22nd to comply.
March 22nd
of this year, and they signed the stipulation in January January 22nd of this year.
Right. So they still haven't complied. They still have an active license. I don't see that we're,
I don't think we should be setting precedents to go from diversion to revocation.
Okay.
This, I mean, not for education. I get what you're saying, and yes, I am a huge proponent of education. But to
So-
jump from diversion to revocation for education purposes that's a huge leap, and that's setting some precedents I don't think we want to do.
okay, but then what's their penalty? They have no penalty. They still have an active license. They don't care. They're not responding. What is their penalty is the problem.
Their penalty is the fine of $2,500, final agency order, and public censure.
But they don't have to do any of this, and they can still have an active license is the problem.
Then when they don't comply, then we go for revocation.
Okay, and that's where my question was before. So how long did they get to comply with this? And do they have to sign this?
So commissioners, the big issue that I'm hearing is the concern that they're allowed to continue to practice with this just kind of hanging out there.
Right.
So you could do like in the previous case, you could require them to go to inactive status until they complete the terms, although inactive status is not a form of punishment. There's suspension that is punitive, but I mean, you could venture away from the active license, and that could be something that Penny again memorializes in a stipulation where they don't get to activate their license until they complete the terms of the stipulation.
But they're already active. That's why.
I know, but you would be placing them on a status that was other than active. So they'd have to go to inactive, or you could suspend them depending on what the commission wants to do. And you could say that they don't get to, if you place them on inactive status, they don't get to go to active status until they complete their education.
Okay. So we can do that. We can place them on inactive. Do they have to sign this, or does it take effect right away?
Well, so they're going to have to sign a stipulation agreeing to go to inactive status. This is something kind of, just to give you guys a heads up, you're going to be under sunset review starting later this fall, and they're going to look at ways to, they'll ask for ways to enhance your program. And one of the things that's kind of on our list to do is to allow you to have that authority to inactivate somebody for non-compliance with CE, like we do with errors and omissions insurance, but we're not there yet. So you could direct Penny basically to send out a stipulation that puts their license on inactive status until they comply with the rest of the terms of this outstanding stipulation.
Marcia, you mentioned suspended. Is there a difference between suspended and inactive, or is it just inactive?
Suspension is punitive.
Okay.
That's a punishment.
Okay. Thank you.
So would the suspension be better, because it should be a punishment for not having complied with the stip?
That is completely up to what you guys want to do.
Well, I did have a question. How long, from notice of continuing education, how long have they had to get their continuing education classes completed?
From January 22nd, and then I believe the first due date was March 20 or May. I'm sorry, March 22nd. So they had 2 months.
2 months. Okay. I just wanted to make sure it wasn't over a year or something like that.
So we could do seeking inactive license until all of these are done in conjunction with the new fine, the final agency order, and the public censure.
Yes, you could do that.
Commissioners, how do you feel about that?
I think suspension sends a stronger message, because then it's actually a punishment. But either way, they have to sign the stip, right? So,
Either way.
yeah.
And if they don't, if Penny doesn't get any response from them, then it goes to the, the harsher, what we were talking about at the beginning, the revocation, that type of thing. If they have to reply, they don't have to. I mean, but if they don't, there's other
So
repercussions.
Let me take a stab at this, Commissioner.
Thank you.
Esparza. So if you're correct that Penny will have the opportunity to take whatever your decision is today back to the respondent and have them sign a new STIP. If she is unable to reach them, if they don't respond, two things can happen. One, she could bring it back to you and give you an update, or two, it could just get referred to our office, and then we would proceed along the lines of whatever the commission orders today. Does that make sense? And this is true not just of STIP violations, but of the earlier investigative matters that you decided today. For the benefit of the new commissioners, if you vote to revoke a broker's license, that revocation does not take effect immediately. It has to go through the due process channels, typically ESP, and if not, our office.
Okay, so are we wanting to do place on inactive or wanting to suspend and then have compliance with the prior STIP and also the new recommendations?
I have a question on the suspension or the inactive. Does the managing or employing broker have to acknowledge that they are inactive or on suspension? Because it looks like we haven't had any response either from the employing broker on this.
What do you mean, do they have to acknowledge it?
Well, I mean,
Are they made aware that this person is now inactive or suspended?
I believe Penny does that, but I can flag that just to be safe.
it was more of a curiosity thing. I mean,
I think she lets them know.
Okay. You know, Renee, I don't, inactive or suspended, either doesn't matter to me. I don't know on suspension, do we have to give a time limit or can it go and because before you usually spend a 30 days, 60 or whatever. Do we have to give a time limit on a suspension?
You don't, but I think it is a little more challenging when you leave it open-ended versus when you set a specific time. But I mean, so for an example, and I'm not suggesting that you do this, if you say you're suspended for 6 months and within that 6 months you have to complete the education and pay the fine, and after 6 months they don't, then it comes back to you, and then Renee, that may be the time when it's ripe to do the revocation round. If you leave it open-ended, and we have one that's on the appraiser side that is like this. He was just told you're suspended until you complete the terms of this, and he hasn't completed the terms, so he's going to be suspended who knows how long. It's been years now, which effectively, particularly with the real estate brokers, when you're suspended for that long, I mean, that's pretty effectively puts you out of business.
So Renee, if we do a suspension and we do a time, we would probably need to put a time on that to have them
Okay, so
get everything done.
what sort of time frame? I mean, it's already been over 4 months and nothing's been done. So we're gonna put a time frame on it to complete everything. We want to do 3 months?
I would say 3 months is pretty adequate. I mean, there's no reason you can't get education done.
Okay, so let me see here. So we're gonna move to do a suspension for 3 months, and within that 3-month time, the 24 hours of coursework needs to be completed along with the fine of $2,500, the FAO, and the public censure. Is that correct?
That works for me. Erica, Autumn, how do you feel about that?
I think that works.
Yes.
All right, so we'll take that as a motion. Do we have a second?
Second.
Thank you, Erica. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
All right, and matter C has been removed from the agenda. Which moves us to matter D, which is complaint number 2023-2225. The respondent signed a stipulation on December 1st, 2023, relating to non-compliance with their continuing education. They agreed to pay a $750 fine plus a surcharge, as well as complete 6 hours of contracts, 6 hours of current legal issues, and 12 hours of electives. It does not look like the fine has been paid, nor the continuing education. The stip that they did assign, failure to comply, would proceed to formal discipline. Staff recommendation is you find them in violation of 1210-217-1M, issue a final agency order, a fine of $2,500, and public censure. And their license is currently on inactive status.
So I think similar to the one before, we can add in that all
So
the stipulation needs to be done prior to them reactivating their license.
Okay, so I make a motion for this one that so all prior stipulations must be completed, as well as the additional recommendations in order to reactivate the license.
Okay. Do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Just to clarify, Renee, and I think you conveyed this, but I just want to be sure. So in addition to compliance, the fine of $2,500, final agency order, and public censure, was that part of your motion?
Yes.
Thank you.
That would be current recommendations, yes.
Which moves us to matter E, which is complaint number 2022-2223. On December 29th, 2023, the respondent signed a final agency order for violations of failure to maintain files for 4 years, violation of any commission rule, unworthy incompetent practice, rules 6.2 competency, 6.20 transaction file requirements, and 6.5 brokerage relationship disclosures in writing. The respondent agreed to pay a fine of $5,750 within 12 months and complete coursework in 6 hours of contracts, 6 hours of brokerage relationships, and 4 hours of ethics. It does look like he did complete 4 hours of ethics course, but not the remaining 12 hours, and nothing to date has been paid on the fine. Within the final agency order, failure to comply, the respondent agreed to a violation of 1210-217-1M with a revocation. As such, division staff is recommending a fine of $2,500, a final agency order, public censure, and revocation.
Now, is this fine of $2,500 in addition to the fine that was on the stipulation that wasn't paid?
Yes.
Okay. All right, so this one would be easy. We move to accept staff recommendation.
We have a second?
Second.
Any discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
The next matter is matter F, which is complaint number 2023-2150. On February 15th, 2024, the licensee signed a stipulation with the basis of violating or pleading to a specific crime under 1210-217-1N, rule violation 623, immediate notification of a conviction plea or violation, and 625 must submit written response to a complaint. The respondent agreed to a fine of $1,500 plus a surcharge and to be on probation to run concurrent with the underlying plea. To date, the respondent has not paid the fine. As such, in the stipulation, failure to comply, we recommend that you proceed with a violation of 1210-217-1M, issue a final agency order, a fine of $2,500, and public censure.
Okay, so I move that before this license, in order to activate this license, all prior stipulations and the current recommendations of $2,500 fine, FAO, and public censure be completed in order to activate it.
We have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Which brings us to matter G, which is complaint number 2023-1966. On December 22nd, 2023, the respondent signed a stipulation as a result of being non-compliant with the continuing education audit. The respondent agreed to pay a fine of $287.50 and complete 12 hours of coursework, 6 hours in current legal issues, and 6 hours in contracts. The fine nor the continuing education have been completed. As such, within the stipulation, failure to comply, a staff recommendation would be to find the respondent in violation of 1210-217-1M, a fine of $2,500, a final agency order, and public censure. And the license is currently on inactive status.
Okay, so I move that in order to activate this license, the coursework on the prior stip be completed in addition to the current recommendation of 2,500 FAO and public censure.
We have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Matter H, which is complaint number 2023-1735. The respondent signed a stipulation of diversion on January 25th, 2024, regarding violation of any commission rule, and rule 6.25 must submit a written response to a complaint. The respondent agreed to pay a $250 fine plus the surcharge. To date, we have not received the fine. As such, staff recommendation would be to proceed with a violation of 1210-217-1M, issue a final agency order, a fine in the amount of $2,500, and public censure.
All right, so I move that in order to activate this license, the prior stipulation, as well as the recommendation of an additional fine of 2,500 FAO and public censure be completed.
We have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
And commissioners, just to clarify these few cases where Renee, you've framed your motion in such a way that I just want to be clear that you are imposing the additional due discipline regardless of the activation status. So in order for the license to be activated, these conditions must be met. But there is also this additional component of discipline that I believe that I hear the commission imposing today, which is the fine, the final agency order, and the public censure. Is that accurate?
Okay, so we're not saying it correctly.
I'm just asking for clarification. I'm not asking you to revisit your motion. I'm just asking the commission if what I've stated is accurate. That
So
you're
yes,
imposing
we
new
would-
discipline, but also a condition to reactivate the license. Is that what everyone
Yes.
understands?
Yes,
Yeah.
that would be correct. So impose the new recommendation And then everything would have to be completed with the new and the old before the license could be activated.
Understood. Thanks for the clarification.
All right, and that brings us to the end of our commission meeting today, June 4th. Look, we're done by 11:10. So everybody who joined for their CE, you get your CE. So that's good. Thank you everybody for joining, and thank you commissioners and staff. Thank you, Angela and Marcia. Thank you so much. Everybody enjoy your summer. We'll see you
Wait, I have a quick question.
In a
Are
couple
we
weeks.
rolling-
in a couple weeks. Yeah, go ahead.
Are we, sorry, it's my first time. I'm still learning. Are we rolling into the executive session then, right now?
We don't have anything on executive session, so that's just reserved if we do.
Gotcha.
But we don't
Bless you,
have any
Renee.
matters. Bless you. But yes, we do have the other meeting at the end of June. So
And, all right, I'll circle back because I don't think I have the calendar invites for that, so.
It's June 25th.
At 9:30, and we'll make sure that they get sent to your correct email address.
Awesome. Thank you,
Hopefully by then you'll have a state Gmail account.
Marcia.
all right. Well, thank you everybody. Have a great week, and we'll see you